Hello everyone, this is Italian Law Firm. Have you ever thought about your inheritance in Italy? Do you have any relatives in Italy with whom you share ancestors? On a comparative law level, we wanted to discuss in this written work the provision of Article 46, paragraph 2 of the law of the Italian Parliament number 218 of 1995. In his will, the subject who owns the inheritance can also include provisions of non-patrimonial nature. He can submit, for instance, the entire succession to the law of the state in which he resides, with a declaration expressed in testamentary form. This provision will take effect after the declarant's death. But what happens if he no longer lives in that state? The answer is that the choice made in that will is no longer valid. These choices are not insignificant when one considers the diversity of principles that inform the civil law and common law systems, given that traditionally, in the first legal system, the principles lean toward protecting family solidarity. At the same time, the need to respect the testator's will is considered preponderant, with crucial consequences for the rights of the legitimate heirs. If therefore the citizen of a state of civil law, such as Italy, resides in a state of common law, such as the United States of America, and excludes his heirs from testamentary attributions, the latter could not enjoy the guarantees established by the Italian legal system regarding the share of the inheritance that the law reserves for the legitimate heirs, provided that he resides there at the time of his death, after which his will can be read. However, to mitigate the possible adverse effects such a provision will cause to the heirs affected by such a will, the Italian legislator has foreseen that if the heirs excluded from the testamentary declarations here discussed are resident in Italy, Italian laws will apply to them. Consequently, it is necessary to consider the place of residence of the heirs of this testator, who, if they were Italian citizens at the time of the former's death, could take action and render in effect the provisions affecting their reserve quota. There was no lack of criticism from those who consider the system that provides for the protection of family solidarity to be overcome, ending up with the safety of the reserved quota without distinction, even of those heirs undeserving of this protection, such as that heir who did not take care of the testator or had violent attitudes towards him, showing himself contemptuous of those same values inspired by the value of family solidarity. Outlining the validity of testamentary disinheritance, at least in circumstances in which family solidarity is not reciprocal, given that it is not contemplated as a cause of unworthiness in those few mandatory clauses indicated by Italian law on unworthiness issues. In this lawyer's opinion, this criticism is forced to deal with the legislator's will to limit the causes of unworthiness to extreme cases. Even for a cultural fact, since we are dealing with norms of a moral nature, family solidarity is a concept that changes over time and should be from time to time weighted, taking into account the subjective motivation and the fact that contemptuous behaviors of the value of family solidarity can see both the heirs and the testators as protagonists. Another problem connected to the one discussed above concerns establishing a fair share in the inheritance system, which guarantees that the testator's heirs obtain a share selected by law in the civil law legal system. The intangibility of a fair quota is not shared by all developed countries, as in the countries of the Anglo-Saxon legal area. Here, the regulations, as mentioned above, give more excellent value to the opposite principle of the absolute freedom of everyone to dispose of their inheritance after death. The complexity of the problem of the legitimate quota, however, has made this traditional orientation subject to discussions and criticisms, which have also led this principle to undergo some derogations. Also in the United Kingdom, there have been rules which tend to mitigate the rigidity of these rules on the freedom of disposal of the testator, introducing the discretionary power of the judge to order patrimonial measures in favor of the deceased spouse to meet alimony needs, an application then established by the Inheritance Provision for Family and Dependents Act of 1975. This provision, however, does not deal with the actual legitimate quota, since the reserved quota is not established by law. It is instead a monetary amount set by the judge. Italian law firm Communications Office issued this article. For further insights into the estate and the civil and common law systems, please visit from time to time the English page at www.italianlaw.com. Peace out.